our series of papers that we have been writing on personal data protection. And there was a paper that we wrote that one other panelist, Dhruv, will speak more about on the overlap between algorithmic regulation, or rather the regulation of algorithms and personal data protection. I think that when we talk about regulating algorithms, we also mean regulating AI, which is an issue I think that is easier to understand for most people, because it's something that they have heard about. But because it's so difficult to differentiate between what is AI and what is not AI, we are going to overall talk about regulating algorithms themselves. And this is important because algorithms are playing an increasingly important role in various aspects of our life, whether it's for work. So if you're a gig worker, even if you're not, if you're just say an IT worker, algorithms determine a lot of what happens at your work, from wages to performance reviews to hours worked and so on. Algorithms are being used in criminal justice to determine rates of, say, recidivism, or to engage in predictive policing in general, say at spatial or geographic levels. They are used in finance to determine, whether you deserve a loan, whether you'll be able to pay it back, how much of a loan you deserve. They're used in healthcare to better triage patients to direct care. They're used, of course, in manufacturing and agriculture. And what is happening increasingly is that they are involved in a lot of conflicts and controversies. So, discrimination, cybersecurity, or the lack of it, which is also tied to a lot of geopolitical considerations. And they have, in general, wider societal effects, say, whether it's through body image issues created through Instagram filters, or even debt traps created through some fintech offerings. So there's a wide range of issues that one can link potentially to algorithms, and which is why a lot of jurisdictions are coming up with new laws or regulations uh, to assess and minimize the harms that algorithms may cause. So China, for instance, has an algorithmic accountability framework. The EU has a proposed AI Act. The UK has proposed a different approach, and these are only the most prominent examples today. And there is, of course, sectoral algorithmic regulation that is subnational. Um, a lot of this regulation is, like a lot of technology regulation, is principle based, which is where we think that certain overlaps come in with privacy law, because privacy law is also often principle based. So the questions for this panel are whether we should have a harms based approach to privacy and to algorithmic accountability, what these overlaps between these two fields of regulation might be, if they should be tackled with the same law, under the same law, or with different laws. And of course, very importantly, what contextual considerations, such as the jurisprudence of a particular country, the application of algorithms in a particular country, and the existing political frameworks available in a particular country should be taken into consideration before arriving at these answers about algorithmic regulation and data protection. So I'll just quickly introduce the panel, and every panelist will speak for 10 minutes. After which we can have a round of questions if there are any, and then there'll be closing remarks, so we can be done within the hour. Our first panelist is Dr. Abhishek Gupta. He is an AI ethics researcher and machine learning engineer. He is the founder and principal researcher at the Montreal AI Ethics Institute, which is an international nonprofit research institute with a mission to democratize AI ethics literacy. He also serves as the senior responsible AI leader and expert at the Boston Consulting Group, where he leads globally the firm's work with clients on technical workflow optimization, and organizational governance to operationalize responsible AI. The second panelist is Udbhav Tiwari, who is the Senior Manager of Global Public Policy at Mozilla, which I'm sure everyone's heard of. He also used to be a non-resident scholar at Carnegie, India. He used to work at Google as a public policy and government relations analyst, and he has also worked at the Center for Internet and Society. So he has a long career in technology policy. Dhruv Somajula, who is my colleague at Vidhi, is a research fellow here at the Center for Applied Law and Technology Research. He is interested in the interplay between law, technology, and civil liberties. He graduated from the Nalsa University of Law, Hyderabad in 2019. And before Vidhi, he's worked at Majumdar and Partners, as well as at the Center for Communication Governance at NLU Delhi, and like Udbhav at CIS. So I think it's a really exciting panel and to me an interesting topic. So I think we can start with Dr. Gupta. 10 minutes to you.
Hi, everyone. Nice to be here and have a chance to talk a little bit about regulations and how it applies to. I think Jay made a very good point around what the different regulatory approaches have been, both at a subnational, at a national level, at a supranational level, as well in certain contexts. And in particular, I think what is interesting is how some jurisdictions have taken a privacy-first approach. Some have looked at impact as the driving factor for deciding how regulations should take shape, how laws should be crafted, and what degree of, I think, guidance is provided to industry as well in terms of applying some of these ideas in practice. And I think one of the other things that has been interesting to see is how these approaches have differed based on contextual factors. And I think you alluded to this at the start as well, in terms of how these have been tailored based on local political frameworks, jurisprudence as well. So if you look at how the United States has approached it, for those who are not familiar, we recently had the Algorithmic Accountability Act of 2022, which was an update from the 2019 version, where so basically it was introduced in February of this year, where the sort of guiding enforcing body is going to be the FTC, so the Federal Trade Commission. And essentially what they require is for companies to assess the impacts of AI, create transparency about when and how these systems are going to be used, and essentially empowering consumers to make informed choices about the automation of critical decisions. So that's been their sort of primary approach to doing this. But also you have certain sort of subnational or state-based regulations. For example, you've got the Automated Decisions Systems Accountability Act, which came out a while ago in California in December 2020. And essentially any business in California that provides a person with a program or devices or device that uses an automated decision system is what falls under the purview of this. And essentially what it asks for is for businesses to annually submit to their Department of Business Oversight a report that summarizes the result of this ADS, so the automated decision system. And again, what you start to see here, which you alluded to in your opening remarks, was this blurriness between AI, between algorithms, between automated decision systems, and that boundary is hazy for the most part when we're talking about it. And then really quickly to also talk about Canada, because that's where I'm based out of. We recently unveiled the Digital Charter Implementation Act 2022. So came out in June, and I mean it's still going through a reading in our parliament, and has a couple more rounds before it becomes formally accepted. But it essentially talks about technology that assists or replaces human decision makers with a rule-based system. So that's how they framed it. What that covers is regression analysis, predictive analytics, ML, deep learning, neural networks, or other techniques. And what it asks for is an explanation of reasons or principal factors that lead to prediction recommendations or decisions, and essentially talks about data rights for individuals and data mobility for individuals as a part of that. And then, of course, we've got the EU AI Act. I won't dive into that because I think probably that's been the most discussed piece of framework in our field. I think what's also interesting, perhaps to quickly mention here, is China and Japan. So China, they had the Internet Information Service Algorithmic Recommendation Management Regulation. That's a mouthful. Essentially looking at algorithmic recommendation activities used by apps and other internet services. So again, you see that there is a bit of a change in flavor in terms of how they're thinking about what systems fall under their purview. And what it asks for is a post hoc assessment of impact of the AI implementation rather than the process behind it, and checking how application of AI influences the balance of power, so between the government, the consumers, the company that's deploying that system. And it's, very broadly speaking, a highly political approach to regulation. And then in Japan, you've got the governance guidelines, so the practice of AI principles. So that was January of this year. And essentially, what it looks at is AI systems in which a machine learning based approach is used, and which are at least partially created by inductively using data. That's how they framed it. It is not legally binding. So that's something that's interesting to observe here. And I suppose voluntary efforts of AI companies, including development and operation of AI systems in their business transactions, and development of a common understanding of the implementation of these AI principles. And last, I think, especially for the Eastern Hemisphere of the world, Singapore had the Model AI Governance Framework. So the second edition came out in January 2020. Put forward by the Ministry of Communications and Information. And essentially, it also gives guidance to private sector organizations deploying AI, internal governance structures and measures is sort of what falls under that purview. And so what we, I think, end up seeing here is that there is this vast array of approaches. And especially if you look at, for example, in Canada, it started with a privacy-based approach. In the EU, it's been driven by high impact, high harms areas, and that being the guiding framework. Are these adequate? I think that's the core question that we're trying to get at and to answer. And I think they all cover different facets of the AI lifecycle, and that's sort of how I visualize whether any of these laws, any of these regulations are going to be enough, any of these guidelines are going to be enough, is the degree to which they're able to cover how impacts manifest across the various stages of the AI lifecycle. And most of them currently don't do it in a comprehensive fashion. They are patchworks. And this patchwork notion actually is important to consider because it's going to have implications as you look at the application of AI systems across various jurisdictions as these come into force, and what that means for the applicability of all these technical measures that are put in place to meet these compliance requirements, and whether that limits the ability for people, for organizations to be able to sell some of these systems across these jurisdictions where some of these things are going to come in force. So that adequacy question, I think, then becomes very important in the sense that we essentially end up in a place where it's not necessary that we're going to achieve adequacy. It's also problematic in the sense that we will experience a fragmentation, a splintering of the kinds of technical controls that are developed, and subsequently the impacts that they have in places around the world. And and I know I've got about maybe a minute and a half, 2 minutes left here, but you can draw precedent, and I know that it's perhaps not completely analogous, but if you look at the impact that GDPR had, and what's commonly dubbed as the Brussels effect. So for those who are maybe not familiar, so Brussels effect talks about essentially whatever ends up being developed in the EU, there's a de facto and a de jure effect that happens around the world. So de jure in terms of law, and de facto in terms of practices, standards that are adopted just to make it easier to comply with what is developed in the EU. And when the GDPR came out, we saw this as a very small example, how cookies started to be implemented across websites, and how they were, and what sort of standards were imposed, and how there was a cost and benefit analysis in terms of the degree to which it was difficult to make local adaptations when they were necessary versus just following along with something that was set in the GDPR as an easier way of doing that. But that only works, by the way, if it ends up being the superset and the highest standard, in which case there aren't any non-overlapping scenarios which are not covered. And that's not the case this time around, where the way AI algorithms, automated decision systems, the way they've been defined is completely, not completely different, but different enough that it requires different approaches. And the adequacy, again, to answer, isn't complete from the perspective of the entire AI lifecycle. So I'll stop there, and of course, would love to hear what Udbhav and Dhruv have to say, and then we'll come back for Q&A after.
Thank you, Dr. Gupta. I think the point about fragmentation is becoming clearer and clearer by the day, and there's probably more need for more innovative ways to ensure regulatory coordination across jurisdictions while keeping their specific contexts intact. So I think next we can move to Udbhav, and Udbhav, if you can focus more on, Indian jurisprudence and Indian context, and what kind of framework in that sense, makes most sense for India. Before you start, I'm really sorry I did not introduce Preeti and Atul, who are helping us with Indian Sign Language translation at this webinar. Thank you so much, both. Udbhav, I think you can start now.
Thank you. So over the course of the next 10 minutes, I think I want to make three broad high-level points. The first is definitely situating where the entire algorithmic transparency debate lies within how privacy and data protection are both understood from a sort of legal perspective, but also from a strategy and digital rights perspective. How does it make sense to situate algorithmic accountability within the right or the fundamental right to privacy? The second is what are the harms that emanate from the use of algorithms and AI versus via the state? So what are ways in which state use technologies that probably fit within the definition of algorithms very broadly, and some of the harms that arise out of them that aren't related to privacy? And the third is broadly the role of the private sector and what forms of regulation are effective at targeting some of the sort of most egregious practices that take place there, and what may work in India as well. So starting off with the first piece, which is privacy. I think that most people who will be watching this webinar may know that India now has a fundamental right to privacy, but I think the fact that I use the term now has is the key operative term there. Even the idea of whether privacy exists as a fundamental right in India has been very contested between the state, the private parties, and situationally ever since we sort of had independence in the late 1940s has evolved over time. And the Puttaswamy judgment a couple of years ago by the Indian Supreme Court is the one that sort of unequivocally said that there is something called a fundamental right to privacy in India. And everything that's emanated alongside that and around that, whether it's the conversation around the Aadhaar, whether it's the conversation around India's data protection bill, and the sort of back and forth that's happening there, I think all clearly point towards the fact that this is a sector that needs regulation, that the regulation that currently exists is inadequate in order to prevent the practices that are taking place in this space, and that what this regulation, if it were to be effective because of how sort of horizontal technology is as a concept, will fundamentally have to be principle-based as a regulation, right? And if one were to keep these criteria in mind, I think you could compare it to what's happening in Europe with the GDPR. Now, the GDPR has been a law for about 2 years, and large parts of India's own data protection law, the last draft at least, were inspired by the GDPR. And the GDPR contains a right to object to automated decision making. What that means is that individuals can say that if there is a decision that is being made about me and it's being done in an automated manner with some caveats, I can object to that decision being made automated in an automated manner, and I can ask that a human be in the loop. In practice, how this has been implemented has really varied in different jurisdictions, and there are certain other concepts in EU law that like broadly place similar obligations upon individuals that use automated decision-making systems. But I think that's at a fundamental point the key, right? Which is that all algorithms and on a lot of the hype around AI are still fundamentally based on data and data pipelines. And those data pipelines are probably going to be the bedrock of any effective AI regulation. And that bedrock of effective AI regulation in the case of India needs to be a good and strong data protection law. Because even if we were to try to regulate some of the other harms that I'm about to talk about in the field of artificial intelligence and algorithmic decision making, it becomes very clear that as long as the underlying data sets aren't obtained in a manner that respects the privacy, privacy practices, and operates in a manner that is fundamentally clean and subscribe to certain best practices that may vary from jurisdiction to jurisdiction, but Dr. Gupta has already spoken about the value of advocacy there, then that data should not be used for algorithmic decision making. And a lot of the harms that AI regulation attempts to, I think, govern will be, I think, dealt with at that level rather than waiting for the harm to occur in the first place. And I think that there are certain aspects of that, like having an empowered regulator, making sure that the state has a capacity to understand the technologies that use this data. And all of them, I think, are like subsets. And that's, I mean, we could have an entire conversation on just that aspect. But what I hope to have established with like at least this piece is that the fundamental right to privacy needs to be actualized in the form of a law. And that actualization must account for the fact that of the users that data is put to, and therefore protect data accordingly. And algorithmic decision-making is arguably like one of those fundamental pieces, right? So I don't think that it's sufficient to have a really strong data protection law, and therefore the harms that occur out of AI systems are completely mitigated, and therefore there is no need for regulation. But if one has to precede the other, and that's definitely an if question, not a given, then it's the data protection law that should exist first to make sure that there are certain baseline good practices in the industry and in the ecosystem at large. And now that leads me to my second point, which is the use of automated decision-making and algorithms by the state. I think that we've seen a lot of examples just over the course of the last maybe 5 to 8 years in India of technologies being used, whether it's, say, for the Aadhaar, where deduplication algorithms that determine whether your fingerprint or your facial scan is similar as someone else's are a form of automated decision-making. There have recently been reports in the Indian media about how certain police agencies treat 80% as the threshold at which they claim a face matches another face, and therefore can be a cause for either investigation or at least looking into certain individuals more than others. And all of these are examples that demonstrate that alongside the privacy issues that surround these practices, right? Like the collection of data by citizens in the case of the Aadhaar, the collection of video recordings at, say, mass events or from public CCTV cameras in the case of the police agencies example that are used, all also have underlying discrimination-based aspects to them. And I'm using discrimination as just one lens. There are many other lenses, a sort of principal human right-based, I think, life forms that are accruing from many of these practices. But like just taking discrimination as the lens by which to analyze this a little further, it becomes pretty clear that even if data protection law, if we had like the world's best data protection law in India and it was followed to the exact by government agencies when they were procuring this data, a lot of the harms that can and are occurring on the basis of discrimination would still continue to occur. And I want to use a parallel from the Netherlands in order to illustrate the point of what has been discovered after the existence of effective data protection regulation in other countries, and why it's quite possible that that may be happening in India too, right? So in the Netherlands, over the last couple of years, there's been a benefit scandal that's been playing out, where there has been a case where it turned out that the authorities were using algorithms to determine whether people are cheating on their benefits or not, right? And some of the things that have come out of that are shocking, right? Like people have committed suicides, like families have been broken apart, children have been taken away from their parents, all because the computer system thought that someone was committing fraud on the basis of how they were spending their money or how they were receiving that money. And an audit revealed that a lot of that simply just wasn't true, right? I think if you were to ask ourselves a similar question, saying what are the ways in which, say, the income tax authorities in a country may be deciding who to go after and who to investigate? What are the ways in which certain applications are accepted or denied when there are, at India scale, like thousands of applications that are sometimes being submitted every minute to every hour for certain services. And the fact that these very important questions cannot be asked, and by cannot be asked, there is no legal framework by which an individual or a group can go to a government and say, we believe these are the harms that may be occurring because of these practices. And here is a law that compels you to be able to give us explanations for why they're happening and to audit it, right? I would argue, in fact, that even if this law existed today, there's probably not enough capacity in the Indian ecosystem to perform these audits in a good and a reliable manner. And I think that points towards the need for why, while certain things, like one could argue, right, like the Indian constitution contains fundamental rights. One of them is that the government can't discriminate people. So you don't need a law for AI, because if you're discriminating, you can just take the government to court. But the thing is that with more technically specific legislations, it's pretty clear that you need an established set of principles. You need processes by which these investigations can be carried out, without which we will end up in a scenario where there may be very serious harms occurring, and we simply will have no way of just knowing them, right? And that othering of the people who have been, in a way, disenfranchised in this case is definitely something that I think only effective regulation can take care of. And in that, in terms of substantive recommendations, I definitely think some of the approaches that are present in the AI Act in the European Union are something that should be adopted in India too, specifically the risk-based approach, right? Like that, depending on the kind of use case for which an algorithm is being put to use, if it's a high-risk case, then there are a heightened level of obligations that should be imposed upon any entity that is using that technology, including the developers of that technology. And if there are certain low-risk use cases, then the level of obligations upon them should be lower, but there should be a common baseline of questions that individuals can ask about the systems that are making decisions around them. And with that, I think, and there are ways in which that can be incorporated in India, though I think that the conversation is still actually pretty nascent. It looks like hopefully we will get a data protection law that accounts for some of these concerns first. And then after that, we may see sectoral regulation before we really see a horizontal law that attempts to deal with algorithmic decision-making. And just in the last 2 minutes, the final points that I'd like to make around the private sector as well is that the global and international nature of technology means that maybe some of the most effective ways of regulating the use of AI in India will be in laws and regulations that are actually applicable elsewhere. We actually saw that with the GDPR, right? Where companies have to comply with laws and regulations in a certain jurisdiction. And sometimes it's actually more cost effective to apply those laws and regulations elsewhere, to apply them globally rather than to make sure that you only apply them in one jurisdiction and don't apply them in the other. We see this for very large technology companies, but I think we also see this for a lot of other sectors as well, unless, of course, a company decides to only bring certain benefits to the jurisdiction that has passed the law. And I think in the case of India, given the timelines that are most likely for law, it's quite clear that the industry needs to do much more than it is doing right now to improve the capacity within the Indian ecosystem to understand some of these issues, both from technical perspectives, but also from allied fields like social sciences and philosophy, law, and a bunch of other things, because they're pretty deep and important issues. But alongside that, it's really important, I think, that industry best practices start filling in the gaps that laws will eventually have to fill. Because I think if we wait for the law to come before industry starts adopting what are some very essential practices, a lot of the harm that we're talking about would have already occurred. For example, at Mozilla, one of the projects that we both work a little bit on and have funded is called the OAT, or the Open Accountability project, which essentially is a toolkit to audit algorithms in a manner that allows other individuals to be able to see how the algorithm is making its decisions. Is it meeting certain baseline criteria, right? Like, so initiatives like that need to be, I think, localized for the Indian context and be more widely adopted in the sector, because it's pretty clear that algorithms and automated decision making are being used in a myriad of ways that are often pretty poorly understood. Yeah, so those are my interventions. I'm sorry, I think I went over by about a minute, but I hope that's all right.
That's fine. Thank you, Udbhav. Thanks a lot, especially for highlighting the importance of sequencing in these laws and talking about how lawmaking through courts and industry standards really fills in when you don't have an actual law passed by the parliament. Dhruv, do you want to go next and talk about overlaps, gaps, conflicts, and possible consonance between algorithmic accountability and privacy law?
Before doing that, I'll just take a couple of minutes to discuss the paper that we had published. We had focused on the need for a coherent regulatory approach towards algorithmic issues, primarily from a data protection point of view. We chose data protection because currently, in recent years, we are seeing a lot of AI issues being addressed or dealt with through principles relying on data privacy jurisprudence. For example, the Siri case, which was mentioned by Udbhav, the Hague District Court had relied on the principle of transparency, which and used the European Court of Human Rights and the right to privacy under that to strike down the use of this particular software by the Netherlands government. Similarly, within various principles available in data privacy jurisprudence, we focused on the principles of accountability, the principles of transparency, and the principle of fairness, because these three principles are not only also very prevalent in several other sectors of law, such as consumer rights, where fairness and transparency are both like established principles of sorts, but also in terms of how these these principles act as some sort of framework principles, and their role is more realized in their interaction with other areas of law. So we analyzed the evolution of these principles in the data protection context and its applicability in the algorithmic issues that are prevalent both in India and in the GDPR. Through the paper, we recommend that while there are definitely positive opportunities of consonance between algorithmic regulatory framework coming in through data protection law, there could also be several places where conflicts could arise, especially if definitions are not clearly scoped out, if principles are not similar in terms of what creates the underlying legislation, and so on and so forth. So regulatory harmonization being extremely crucial for a well-developed algorithmic regulatory framework is essential. Now, I'd like to take a couple of minutes to also talk about two things. One, the kinds of overlaps and positive consonances that do exist in terms of data protection jurisprudence and algorithmic issues. And I'd also like to point out a few areas where data protection law is just not enough, because there are gaps in what it can do and what algorithmic systems present as issues, and also where like differences in laws, such as, for example, in the AI Act and the GDPR, might directly result in conflict because of how certain provisions are worded and how they're treated. So firstly, in terms of overlaps and consonances, I think Udbhav had touched on this, that the idea of consent, the idea of notice and consent, and the idea of data minimization, these are definitely applicable both. They are already prevalent in various global understandings of privacy law, be it Australia, Canada, the GDPR, the PDP bill, which is now withdrawn. So there are several examples of data minimization principles being prevalent. And the importance of these issues, such as the requirement to take consent, etc., are very key to several algorithmic systems and their operations. Secondly, there is a similar sort of issue regarding how cross-sectoral frameworks have to be devised, both for the regulation of personal data protection under data protection law, as well as the use of algorithms by various sectors. For example, currently in India, the RBI is the regulator responsible for overseeing algorithms used in financial markets. Whereas if a data protection authority was in place in India, one of the key roles of the data protection authority would also be to figure out how this cross-sectoral balancing of various concerns and various risks, etc., have to be done. So in both these areas of law, there is a common issue for which a solution would be similar for both of them. Lastly, there are a few examples which sort of flow like from each other. For example, the AI Act has a certain classifications such as high-risk systems, prohibited systems, and low-risk systems. Now, high-risk systems are required to undergo a risk management procedure where several pieces of information regarding the possibility of bias, etc., of that system. There are several aspects that developers of these systems have to inform the users of these systems. Now, this sort of flows in directly with the provisions of the GDPR, which require any data processing which could possibly have high risk consequences to user rights must undergo an impact assessment. So the AI Act, in fact, directly provides that this information released under this section of the AI Act can be used for the impact assessment under the GDPR in Article 35. So this is just an example of how once we devise a certain framework which allows us to regulate or which allows us to access our own data, for example, under data protection laws, we are not only empowering people to resolve privacy harms, but also non-privacy harms. However, this directly leads me to my point regarding the issue of conflicts and gaps. Now, there are several AI ethics-centric issues, such as opacity, the issues of interpretability and explainability, the idea of the need to understand how did an AI system come to this particular decision. Now, these sort of issues or the lack of a representative data set which may cause bias, etc. These are not issues that can directly be solved by data protection principles, and therefore would require specific tailoring of AI regulatory frameworks as well. For example, there is a direct sort of clash in terms of the provisions of the GDPR and the provisions of the AI Act, which came out very recently. The AI Act requires this risk management systems that I was talking about earlier. As part of the risk monitoring systems, there is a requirement for conducting bias monitoring, which means the developers of high-risk systems would have to account for areas where there could be potential biases, etc., within their data set, which may result in the system not performing well. However, this kind of processing of data for this particular monitoring may involve processing of extremely sensitive personal data, such as data based on ethnicity or race, sexual orientation, political views, etc., which are all issues, which are all examples of sensitive personal data that are covered under the GDPR, and for which the processing of these particular information sets is simply prohibited directly. Now, over here, sort of save for clause has been made to allow this particular kind of bias monitoring. But this is just an example of how different frameworks may butt heads, because the AI Act has been created in a scenario after the creation and implementation of the GDPR. And in India, where, for example, we are starting out in scratch, we have an opportunity to ensure that a more coherent form of framework is developed, wherein an awareness of both the issues that primarily underpin algorithmic systems and their harms, then the possible harms, vis-a-vis the possible benefits of data protection legislation, have to be narrowly tailored and well defined. That will be that from me, Jai. Thank you.
Thanks a lot, Dhruv, especially for talking about how principle-based legislation can sometimes dilute other principle-based legislation rather than strengthen it or lead to a mutually strengthening process of rights. So I think at this point we can open it up to questions. What you can do if you have a question is type it in the Q&A box, or else raise your hand if you prefer to ask your question directly. We'll just wait for a bit for questions to start coming in. There is one question from Harsha Krishna. Should privacy law be framed with an ownership approach instead of harms-based approach? For example, the individual is the owner of the data. This would mean that the government should not be involved in monetizing data that was collected using taxpayer money. Furthermore, it will promote innovation in AI techniques, where techniques such as privacy-preserving computing, differential privacy are being pursued. Would anyone like to take this on the ownership approach to treating data like property approach to regulation?
I mean, I can give some opening thoughts just to start the conversation, and would love to hear what Bob and Dhruv have to say as well. And I'll start with a slightly technical lens to what an ownership approach looks like when we're talking about data, because I think that's been the failure point for most of these approaches, and it essentially stems around the complicated life cycle of data and what ownership actually means. It's from an, I think, idealistic standpoint, makes sense to talk about data being owned by the individual, but there are also computed aspects of data in the sense of additional things that are inferred about a person or are generated about a person, and in which case ownership actually becomes quite hazy in terms of whether it's actually something that's owned by you, or if there are attributes that are computed about you and are stored with the platform, their ownership becomes hazy. So that's one facet to it. The other facet, I think, is how do you actually operationalize such an ownership model when we're talking about what privacy means in this context? And we talk about data cooperatives, we talk about all these sort of innovative approaches to operationalizing data ownership, but it becomes incredibly difficult then to restrain the use of that data unless you use and Harsha's correctly pointed out privacy preserving computing here. Differential privacy is perhaps one approach, but I think what's perhaps more important is thinking about secure multi-party computation and actually applying approaches that don't release data in any form, even in a limited fashion outside of those data cooperatives, as an example, where it's really computation that happens and computation that's distributed rather than data being distributed in that ownership model. But anyways, I'll stop there and turn it over to Udbhav and Dhruv.
I completely agree with Dr. Gupta on the idea that it is very difficult to nail what the ownership status of that data, which is created by inferences which clearly did not exist until that point in time. So if a big software company has done me a favor and inferred certain behavioral tendencies of mine, etc., do I suddenly start owning that data set? I think the realistic aspect of what does it mean by ownership and what are we trying to achieve with ownership needs to be further questioned over here when we talk about the idea of a ownership model versus a harm model. For example, what the GDPR has tried to do and what I think the PDP bill has tried to do is to allow greater control of or like for an individual over his data, which includes access to the data throughout the life cycle of its processing, awareness about who has it, who does not have it, and rights regarding erasure, portability, etc. Now, I understand that there's a aspect of monetizing data like in that question as well, but it is not a binary question of if not this, because a harms-based approach is necessary for being able to address issues which individual data principles cannot by simply opting out of a contract. Like a harms-based approach then develops a framework in which transparency obligations, security obligations, a whole bunch of additional obligations are created in a regulatory space that allow these rights to be realized.
Thank you, Dhruv. Udbhav, do you want to add something?
I mean, the only point that I'll add is, I mean, I think slightly philosophical one. It's that trying to treat data as something that can and cannot be owned by individuals rather than privacy being something that is inherent to one's being can lead to some like slightly worrying constructs, right? Because if individuals own their data, which is similar to sort of a property right approach, which is, you own certain things and therefore you can do whatever you want with them, then at least my personal belief is that the set of practices that you can contract away are much, much wider than those things that are inherent to you as an individual and as a human being, and therefore are things that, that there are certain limitations to what can be done, what can be done with it, and certain practices where even if you have contractually agreed to them can still be illegal because of the harm that they cause you. So I think that the overall, like the sentiment behind the question, which is what if data could be owned by individuals and therefore the state should not make money from it, is a legitimate and a valuable one. But I'm not sure whether I would call it ownership of data rather than treating privacy as something that is inherent to every individual's being, and the state therefore cannot interfere with it. Yeah, that's it.
Thank you, Udbhav. That's a really good point. I've also seen this is not a, necessarily a technical method, but from what I've seen in some AI models, is what they do to operationalize this sort of ownership is that they provide licensing conditions that require the consent of every person who has contributed to that model, especially for some language learning models, such as the ones that were built for Maori languages. So I think there are certain mechanisms one can use that don't require that much advancement of technology as such, but that can still respect the ultimate, let's say, control over data of the data principle. I think the next question we have is from Siddharth Manohar. How do regulators and businesses work to address issues such as bias and other problems in data sets or algorithms? And what spaces can be equipped for this? Who would like to take this one?
I can start because I was reflecting on this as I had a couple of minutes as Dhruv and Udbhav were speaking on the previous question. It's interesting that, it's typically the issue of bias that's brought up, and it's usually framed as a data set and algorithm thing. One of the things that I've been reflecting on recently is that, and Udbhav also touched on it a little bit when he was talking about, data pipelines and all of these things. One thing that we need to start considering now is looking at pre-trained models and model artifacts, which aren't necessarily completely covered under data pipelines or data artifacts because they're not treated as such. They're in a sort of limbo at the moment. And you can look at some of the stuff that happened last week and the week before that with the recent diffusion based model. So you look at something like Stable Diffusion, Midjourney, Dolly 2, and when the weights for such pre-trained models are leaked, they can wreak havoc on what's possible with those systems, not just from a bias perspective, but also other harms that emerge. For example, generating pornographic content, other harms that don't take into account consent. And when we're talking about what spaces can be equipped to handle this, I think another one of the points that was made earlier is on rightly equipping regulators, policymakers to even ask the right questions. So this whole point around model artifacts, there are few people I think who are in positions of power who actually understand that model artifacts today are not covered under under traditional formulations of regulations today. And so, and this might be a hackneyed point, but we need to equip policymakers and regulators with teams who are able to operate at the vanguard of what's possible from a technical perspective today. And the reason I'm bringing a technical lens is because I think it's equally important to consider, because that's where some of the advances are happening, and being able to bring in those. And by the way, I'm by no means saying that technical approaches are the only way to solve it. I'm deeply cognizant of the socio-technical manifestation of AI systems. It's just that I think if we don't emphasize it enough, we miss out on some of the bleeding edge possibilities, like with what happened with the leak of the weights for the Stable Diffusion model and the problems that it's been causing on 4chan and Reddit as a starting point.
Yes, absolutely. Thank you. Dhruv, Udbhav, you want to add anything to this?
I mean, I think that the only thing that I'd add is that issues of bias are actually pretty poorly understood, right? Like even from a sense of what the term bias means. I mean, things like race and ethnicity and skin color, those are issues that have been studied and spoken about. But like in India, for example, I would argue that attempting to understand bias in a data set on, say, the principles of caste is both a much harder and a far more unique problem. And I think that the field is approaching some of those questions with some in a pretty interesting way, but it's pretty clear that it needs a lot of investment on very fundamental sort of like research and development, like universities, publicly available research, like at that sort of very baseline conceptual level that I think is not necessarily something that's at the stage where regulators like should be able to deal with it. It's something that I think requires more systemic and fundamental research to be understood in the context of India before a lot of the principles and hype that generally exists around these terms is available. Is just blindly applied to India. On the sort of how can businesses work to address these better, there's a lot of really great work that's happened around the world. I mean, I would say the good thing about things like bias or anti-bias work when it comes to AI is that it's mostly a process-driven question. Of course, there are technical questions and there are certain outcomes that you need to prevent, but if you follow certain steps, which probably add time and cost money and resources, like that is the way you understand whether bias exists in data sets or not, right? Like you study them, you're deliberate about what goes into them, you're deliberate about the outcomes that occur. And those are all things that businesses don't really need regulators or laws or regulations to tell them to do. Organizations like AI Now, Mozilla has done a lot of work and put out some of it as well. I think are entities that like can serve as organizations that provide some of the process and the work that is required for companies to be able to understand things like bias in data set and algorithms better. So I think making sure that there's awareness at like the leadership level in these organizations that they think it's a deliberate problem that they want to solve, and not just to tick a box, and one where there is sharing of best practices in the sector can all lead to better outcomes. I think 15 to 20 years ago, if you looked at the average state of cybersecurity within India and the technology sector, and now, a lot of the change that has taken place, and it's certainly improved for the better, has not been because of laws and regulations. It's been because people have understood problems better, they speak to each other better, and there is recognition at a leadership level that these are issues that need to be dealt with. So I think all of them equally apply.
Thank you, Udbhav. So I think I'm conscious of time, so I'll club the next two questions together, and anyone who would like to take them can do so. Samir asks, is it really prudent to prohibit AI systems through legislation to use features like gender, race, sexual orientation, which may lead to discrimination or bias? And Harsha has another question, which is, are there any safeguards to protect citizens against monitoring and surveillance by political parties? For example, a couple of political parties said they will focus on hyperlocal campaigning. They now have access to Aadhaar voter ID linked information and thus can reverse possible safeguards offered by the secret ballot system. Is there a way to regulate direct monitoring of citizens by various political parties? These are the questions we have. You can take any of these questions.
I can start if we want. To answer Samir, if it is really prudent to prohibit, I think it's already done through. I'll take the example of the United States through some of the Equal Opportunity Act. You look at the Americans with Disabilities Act, or fair lending and credit. Those already prohibit the use of these features, right? And I don't think that because those are already protected attributes, and we have precedents for not using them. I think it's really the problem comes when proxy attributes continue to, or rather other attributes continue to proxy these features, and those are much harder to get at. And that's really where, when you're talking about legislation, I think that's where you need to think about. And I think Udbhav was making the point, like, do we even really understand what bias? Most of the frameworks, like the Western frameworks, really look at bias through some of these lenses, and that's not necessarily applicable fully to the Indian context, where bias also manifests in other forms that aren't necessarily covered by some of the things that are gender, race, sexual orientation, which are part of the canon of legislations in the Western Hemisphere. And then, when you're talking about possible safeguards for balloting and how political parties use it, it's really, they're just another actor, in my opinion, in that ecosystem of people purchasing data from data broker entities. And I think it's the broader leash that we need to put on data brokers and how data moves around between different actors and the purchasing activities behind that, because political parties essentially are just yet another, and they can always subcontract it out to another firm to purchase that data and then use processed insights from that firm to then drive their activities, even if the political parties are directly prohibited from doing so. So I think that's what I would say there is what needs to be the focus of our attention.
I'm happy to just very quickly answer both of them, like just mostly adding to everything Dr. Gupta just said. On the first piece, which is really proven to prohibit AI systems to use features like gender, race, and sexual orientation. So I don't think that any law would prohibit you from using someone's gender in an AI system. They would prohibit you from treating them differently because of their genders within an AI system, right? So when you're filling a form, it will still let you pick whether you are male, female, or a third gender, or X or other, and and it's not like that input won't exist in the data set. It's that the output shouldn't be different on the basis of which gender you selected in an unfair manner. And I think that and the same thing applies for all of the other aspects of that question as well. So I don't think this is necessarily about whether individuals should not collect these data points at all. Firstly, or organizations, I think the answer to that is yes. If you don't need it, don't collect it. But if you do collect it and you do have it, then it's very important to make sure that it's not influencing your algorithm in a negative manner. And that I think is, your outcome in a negative manner. And that I think is very much a prudent thing to do. On the political parties front, I think that broadly everything that's been defined in the question is something that is purely a problem for data protection legislation. Like most of the things described there would either not be possible or you could hold someone accountable for if we had a good data protection law, and like it's all the more reason that we have it.
Dhruv, anything to add?
Just a couple of points. One, yes, I completely agree with Dr. Gupta on the data broker aspect. I think that is where, like, I think rather than worrying about reverse engineering the voting and the secret ballot system, the concern is targeted advertising, targeted influencing, the idea of like issues such as Cambridge Analytica, which happened a few years ago, and similar kind of micro targeting, micro influencing, using unfairly obtained data, or like influencing you without like, or in an unfair manner. That is the crux of the issue, I'd say. And in that scenario, yes, absolutely, the focus, I think one of the most important things which nobody talks about in data regulation is the transfer of data between parties and how it is treated vis-a-vis merger, acquisitions, reorganizations, etc. These are like a current Indian law. The SPDI rules has a particular provision on disclosure of information, but that is by far like an extremely low bar to cross. So there has to be greater focus on how we treat data, how we treat transfer of data and use of data by various entities, number one. Number two, in like I echo Udva's point regarding one, the issue of bias or discrimination is not the same as the issue of taking in the input. Like, yes, actually, there in some cases, there is concern of underrepresentation of a particular gender or a particular race or something of that sort within our training data set, which may lead to inaccuracies like, which is like, it is not exactly bias. It is more of a, it's not design bias as much as it is legacy bias, because the training data set did not contain enough information to train the AI system to do its output properly. But we can also see that these all these data points are sensitive personal data. They would be classified under sensitive personal data, especially the sexual orientation of somebody. So yes, like, it will normally be prohibited for being processed unless it falls under certain consent or public interest paradigms.
Thank you. If it's okay with everyone, we can just take 10 more minutes so that panelists can make their closing remarks. If it's not okay, just let me know. So Abhishek, for you, if you would like to make any closing remarks, particularly, I think the point about technological development, I really like that in terms of focusing funding and efforts, regulatory efforts towards technological development that is in line with regulatory goals, because the payoff can be so large. So if you want to talk about that or anything else that you missed talking about.
Yeah, no, absolutely. I think this has already been such a fantastic discussion with a lot of insights. I've just been reflecting. I think, for me, the first thing that really sticks out that we need to ensure happens in the space of regulation in terms of policy making is making sure that we adopt a standards-based approach, because in a lot of places, I think failures in operationalization are happening because there's a lot of vagueness in terms of what actually needs to be done. And there's inconsistency in how different firms who are actually then, ultimately responsible for putting these, regulatory requirements into practice, end up interpreting them inconsistently, and even the evaluation of whether something has been done correctly or not ends up being open to interpretation, because there isn't a standard underlying all of that. So a standards-based approach, I think, will help drive consistency. Whether the standards are going to be correct, comprehensive, we don't know yet, but I think at least they will help to drive consistency and a common basis for evaluation from which we can iterate and continuously refine to get to a place where we are actually achieving our stated goals. The second thing, I think, around empowering regulators, empowering policymakers is very important and has been talked about a lot. I think equally so, we need to educate technical stakeholders on the policymaking process as well, because I think there's often a gap there in terms of how this actually happens in practice. And of course, it differs across jurisdictions. And the reason for doing that, I think, is that it will help technical stakeholders make recommendations that are actually helpful because they understand what the process is. And then finally, from a technical standpoint, really bringing in people who understand what the capabilities and limitations of bleeding edge systems are, where the research field is moving, and who can make informed comments on where the field is headed in the near term. By the way, I don't believe in making forecasts that go beyond 18 months, because I think the field is moving just so quickly that anybody who claims to have that foresight is actually tricking you, because it's possibly impossible to do that. And so I think those three things would be my sort of key messages, which is that, looking at standards-based regulations, empowering regulators, but also technical stakeholders towards understanding what the policymaking process is, and incorporating technical experts who can inform what the near-term evolution of the field is going to be, so that you can guide regulations and policymaking on that front.
Thank you. Udbhav, I think we can go with you next. There is a question that was directed at you specifically that came in that I missed asking earlier. So it's Udbhav mentioned how one should start with the Data Protection Act followed by other principle-based laws. How would this work? As Dhruv mentioned, it could weaken or interfere with the functioning of the other laws. So should the government focus on all, or will it end up being a litany of patchwork legislations? So if you can answer that, as well as make other closing remarks that you would like.
Sure, thank you. On the question, I think that technology regulation, almost by its design, will always have different pieces that conflict and maybe not very perfectly fit with other aspects of technology regulation. Even in India, where for all intents and purposes, I think that we have one technology law, which is the Information Technology Act. But even just that, in the way that has interfered with the Ministry of Information and Broadcasting, and what happens in the broadcast sector, what happens in the competition sector, what happens in the telecommunication sector. That's just an example that as long back as 2000, when a lot of these laws were first passed, there was conflict then, and there is conflict now. So I think that the idea that there may be a singular law that will govern everything and nothing else will be needed after that is simply not how technology works. And it's also very unlikely to imagine a scenario where one is able to craft a law that doesn't have some of this overlap and some of that inherent conflict. But I think that does not mean that that these conflicts cannot be resolved. And neither does it mean, I think, that the aspects of a data protection law that conflict with what sectoral or dedicated AI regulation will contain are unresolvable concerns, right? There is always going to be a little bit of a trait, you will cover certain issues in one that maybe you should have covered in the other. Certain protections may get delayed and not come as soon as they were actually supposed to. But I think that's policy making, and that's lawmaking in general anyway. So yes, completely acknowledge the conflict bit, but I think that's one of the perils, but also definitely the promise of regulating technology. On general closing remarks, I think a lot of the stuff that we would have wanted to say has been covered in this really good discussion so far. The only thing that I think I would like to add at the end is that it's very easy to look at AI and algorithmic decision making as things that are, mostly about privacy, a little bit about bias, and it ends there. But I think that we must understand that the scope of their work, the impact that they have on society is like very vast, right? Now, just to like, for example, we just had, I don't know, like a 1 hour, 10-minute discussion talking about algorithmic decision making, and we haven't really discussed like the labor and the gig work aspect of it. And that is arguably something that there has been more progress, I think, on that front in India on both the sides than on certainly on privacy and data protection, but also like most other areas of technology. And the reason I raise that as an example is that I think points more and more to the need for why like certain practices in some of these aspects need to be regulated, and also why the regulation may not necessarily be the solution that everyone is looking for, and that it may require other forms of engagement with polity in a society to better understand a lot of these harms, right? And we've seen that happen even outside of India and Europe, like with the drivers co-op and like people using data access requests to understand how they're being priced, and the wages that they're being paid, to the benefits scandal that I mentioned earlier. All of these are just different dimensions of, I think, the kind of problems that you will face when you try to take a kind of technology or a kind of practice and apply it horizontally in society. So yeah, just that point, which is that there are many aspects and issues of this that we haven't really covered, and each one of them, I think, are equally crucial and important. Yeah.
Thank you. Thanks a lot, Udbhav. Dhruv, from your experience on working on this paper, on other PDP papers, as well as working on operationalizing some responsible AI frameworks and such, what closing remarks would you like to make?
Just a minute to sort of also address the other questions that was given to Udbhav. To whoever asked the question, I completely agree with Udbhav. I do believe that the data protection, a data protection legislation is a great starting point, and its potential clashes with potential algorithmic issue based legislations are luxuries we desperately want to get as quickly as possible, because we would want to resolve those conflicts as well. But it's not ideal that we don't have the first starting point yet. So fully on board on the idea that it's like having a data protection law is actualizing the rights that are needed to be granted to a lot of citizens right away, and we can then address its conflicts with AI systems, etc. Go from there. Number two, in terms of actualizing these points of how do we set out regulations and frameworks, etc. I think there does need to be a lot more effort put in terms of engaging with the entities who will be doing this processing. The biggest data processors and the biggest data fiduciaries will be the government, will be big corporates, and there needs to be a lot more awareness in terms of how processes and either through codes of conducts or guidance notes or whatever, the simple act of how can consent be taken is a very complicated question, depending on which operation you want to take that consent for, and among how many people you want to take that consent for. So there simply needs to be a lot more focus on actually getting the people processing the data and the data principles themselves at large across India. There needs to be a lot more awareness on both ends on how these principles play out, number one. Number two, there needs to be a consistency in terms of the principles underlying any legislation. For example, the principles underlying the data protection law were to enable certain rights to citizens, to require certain, or to put certain obligations on the data processors and fiduciaries. And these are evolving from a space of individual centric approach. This is also parallel to the GDPR, whereas, for example, the AI Act is mostly targeted towards people who are developing these software systems and not necessarily focusing entirely on the people who are going to be using these systems then. So there needs to be a sort of a regulatory sort of consonance in terms of how like the principles for each sector is consistent. Like individuals are centered in data protection law. Individuals would need to find a way to also realize their claims in non-data protection issues coming out from AI systems.
Thank you, Dhruv. I know that there is probably a lot more to say because even though this is such a nascent issue, it's really thorny and touches every aspect of society as we've realized. But there is only so much time, and of course, there's only so much attention one can command from listeners. So, with this final thank you to all the panelists, Dr. Gupta, Udbhav, Dhruv. You have been really quite insightful, and I have enjoyed listening to you, and I have learned a lot. And thank you, of course, to Preeti and Atul for helping us with the ISL translation again. And thank you to the attendees for being patient listeners. We'll see you next time. Bye.
Bye. Thank you.